Alrighty, peace, love, and law, everyone. We would like to welcome you to In God We Trust. In God We Trust Academy podcast. Today we're going to be speaking about equity, acts, and realm, and this is from season 2, so this is a rerun. So you guys do please enjoy. Alrighty. Do not forget, guys, in our upcoming class that we have this Saturday, private administration, private court settlement, lawful money protection, easy to use financial strategies. And this will be December the 7th, 10 a.m. to 4 p.m. Central Time, in person 250, live stream 200. The location is in Huntsville, Alabama. If you're on live streaming, then, just participate. You got until the 4th, so you got 2 more days to register in. A lot of things are going to be dropped in there, teaching you how to handle your affairs. But until then, guys, enjoy this work session. And this, again, like I said, this is from season 2. So let's go. Appreciate that, Ermac. He said, just bought a mastering, tax-free, living great info. Appreciate you. Use it to the best of your knowledge and use it as a great tool. It will definitely bring you more fortune. Let's get in it. Alrighty.
Peace, love, and love, family. Today is April the 3rd, 2023. Welcome to Morris National Republic of Peace work session. And we just give thanks for each and every last one of you being here and to your attendance, as we know that you could be doing anything else at this time, but you decided to bring your attention here. So may your attention pay you. May your attention pay you in service. We give thanks to the Almighty just for being here today and establishing everything and who and what we are as what we were created in the first place. Just we're returning back to our sovereignty and our inheritance as God has given us. And we give thanks for free will and being able to operate in free will and to also fulfill our purpose as well. No matter anybody's belief, we also just give thanks that we're just here and able to be here for a common cause and move things in a direction for a greater good, which is still all in purpose, no matter what, no matter how anybody sees it. So we just definitely give thanks for those things as well. Anything that you hear today is for educational and religious purposes only. If anybody is seeking any form of legal advice, seek a legal advisor or seek an attorney. But other than that, how you guys doing? Everybody's great?
All is well. About yourself?
Yes, sir.
We good. London
Pretty
said,
good.
hey.
Bridge.
He told us, hey, Bridge.
So everybody, like anybody got any good news? Any good news before I get started? I'm only doing one person anyway. Anybody got any good news? All right, Raina, you got good news? Then I want to hear your good news.
Hey, family. Okay, I got some good news, but I still got some work to do, right? So, I buy lottery tickets, and something like told me to keep them all, even if they was a loser ticket. But when I turned it on the back, it has a bond number on it, and so I took it to TreasuryDirect.gov, and it's one of them was worth $5K. So I guess they all have different values. I I still got to do my research on how to cash it in, but it's bond numbers on the back of the lottery tickets.
It was an investment anyway.
So would that make us the holder in the due course of the bond?
Yeah, the holder in due course of that particular ticket. Now, whether it has any interest related to it that's still running or pertains to it, then that's another thing.
Okay. That's my good news, y'all.
All right. Okay, so all right, Tamika Todd, and then that's it, and we finna jump it off. Go ahead.
I just wanted to give a testimony as far as my bills. The young lady that came and spoke last week, as far as the remedy that she got, when it came down to looking up the wire number and everything for my bank. I had wanted to wait at least a week before I had came on, so nothing reversed. Everything still is good. So I was able to get a remedy in that point. I mean, in that regard for my bill. So that's a weight off of my shoulders.
Congratulations.
Thank you.
All righty. So, Equity Acts in Rem. Are y'all ready today? Are you guys ready? You guys don't look like y'all ready. Are y'all ready? Let me see y'all game faces. See y'all game faces. Y'all got y'all game faces on? Y'all ready? Y'all gotta be ready now.
And let's
mean
go.
when I say ready too, that also means you in your studies. That mean you studying too. That's what that mean too. Now it also mean you in the back. You got good character. You know how to go study and seek for yourself. Now that mean you ready. You studying now. Y'all studying?
Hell yeah.
All right. Make it make sense. Make it make sense. All right, so let's get started. Equity acts in rem. All right, equity acts in persona and not in rem. This maximum at one time expressing a rule without exception has now become little more than a mnemonic clause to enable the student to remember the fundamental theory underlying equitable procedure. It is the purpose of this note to explain in part at least this categorical statement. The maxim has been defined generally as meaning that the equity dealt primarily with the person and usually only through him with the rest, and rest meaning property, or that a decree of chancery spoke in terms of personal command to the defendant, but its directions could only be carried into effect by personal act. Okay, so another writer has said of the maxim that it is almost always used to express the characteristic, form, and mode of enforcement of equity decrees, which command the party to do or refrain from doing some act enforced by coercion applied to the person, as distinguished from the ordinary judgment at law, which established a right in the plaintiff. All right. Okay. So it enforced by actions of the officers of the state. The origin of this method of procedure has been ascribed to the fact that in the infancy of the Court of Chancery, while the chancellors were developing their system in the face of a strong opposition, in order to avoid a direct collision with law and with the judgments of the law courts, they adopted the principle that their own remedies and decrees shall operate in persona upon defendants and not in rem. Watch this. However, all these attempted definitions are inadequate to give us an intelligent understanding of the maxim. Yet such an understanding is essential if we are to grasp what departures have been made in the present day equitable procedure. All right. Hofield states that the phrases in personam and in rem, in spite of the scope and variety of situations to which they are commonly applied, are more usually assumed by judges, lawyers, and authors of authors to be of unvarying meaning and free of ambiguities, an exact opposite of which is, however, true. He goes on to state, all right, the antithetical pair of expressions in persona and in rem is constantly being employed as a basis for classifying at least four distinct matters, and the respective meanings are not the same for all the different situations involved. First, we have a fundamental classification of property rights as rights in persona and rights in rem. Second, there is a well-known classification of all judicial proceedings or in actions in persona and in rem. Third, there exists and closely related classifications of judgments and decrees and corresponding jurisdiction of courts in persona and in rem. Fourth, such enforcement is in persona or in rem. Okay. In the treatment to follow, the reader must bear in mind, both in scrutinizing statutes to be considered and analyzing cases to be cited, just with which of the above four breaks down the legislature the courts are dealing. While it is true, as we observed, that equity originally acted only in persona, yet numerous situations developed where such action was inexpedient, impractical, and ineffective, and the law courts, because of rigidity of form and peculiarity of these remedies, were unable to grant relief. Suppose, for example, that the legal title, listen what they said, the legal title of a trustee became vested in one incompetent to act as trustee or to convey the legal title to a successor, equity, acting only in persona, could appoint a successor to act as a trustee, but could not vest the legal title in him, nor in order the title to be conveyed, since the holder had no power to convey. Or suppose A, non-resident vendor, contracts with B, a vendee, to convey land located where B resides. Okay, here equity, requiring jurisdiction in persona, would be helpless to compel A to convey a legal title if A remained out of the court's territorial jurisdiction. They don't have one, so they don't have what? Personal jurisdiction. All right, making personal service impossible. Or assume a situation where a non-resident claims constituted a cloud on a title to land within the court's jurisdiction. Here also, a court of equity would be helpless if it acted only in persona. All right, because there's no personal jurisdiction. So in order to get the one who owns the actual property to come forth, you have to do it in what, guys? You got to do it in rem, right? Now I can get the owner to come forward because it's about their property, even though they're not within the jurisdiction. It's about the subject matter. Y'all see what I'm saying? Zeros if you with me. Zeros if you with me. All right. So it says many more comparable situations could be cited. It suffices to say that the frequent recurrence of such prayers for relief, which equity could not grant, led some courts without statutory authority to act upon jurisdiction in rem, while others were enabled by means of statutes, where the rest is within the court's jurisdiction to notify the defendants in some form or another and act on the jurisdiction in rem thus required. Pennsylvania has such a statute, and it is the purpose of the article to consider some of the changes wrought by it and some of the problems it has created. All right. So the Act of 1859 provides as follows: it shall be lawful for any court of the Commonwealth having jurisdiction upon the special motion of the plaintiff or plaintiffs in any ensued equity which has or shall be instituted therein concerning goods, chattels. So that automatically means this is forms of property. So this has to be in rem. Goods, chattels, lands, tenements, or hereditaments, or for the perpetuating of testimony concerning any lands, tenements, and so forth, situate or being with jurisdiction of such court, or concerning any charge, lien, judgment, mortgage, or encumbrance thereon, or where the court have acquired jurisdiction of the subject matter in controversy, all right, by the service of this process on one or more of the principal defendants, to order and direct that any process be served upon any defendant or defendants therein, then residing or being out of the jurisdiction of such court, wherever he or she or they may reside or be found, and to proceed as effectually as if the same had been made with the jurisdiction of such court, which is why they have diverse jurisdiction, diversity of jurisdiction. That's the reason why it even exists, simply because that. And you can go based upon the actual, particular subject matter. What is the damages that has been caused to the property or the that has been, basically they're trying to deprive you of. So it says, whenever it shall appear to the satisfaction of the court that any defendant or defendant in such any suit equity cannot upon diligent inquiry be found so as to be personally served with any process to be had therein shall be lawful for such court to make an order upon such defendant or defendant similar to the requirements of such process, specifying the time when compliance therewith must be made, and to proceed as fully and effectually as if such process had been duly served within the jurisdiction of such court, provided that a statement of the substance and object of the bill and a copy of such order be published in such one or more newspaper, and at such time such court shall by special order direct no order or process of contempt shall be made or issued under this act. Like, it's all about making your claims, y'all. If y'all ain't hearing what they're telling you, make them claims. Any attempt to analyze intelligibly this statute seems naturally to give rise to three lines of inquiry. First of all, we wish to determine upon the theory and the validity of such legislation so apparently revolutionary of historical masculine that equity, acts, and persona can be sustained. Secondly, what are the requisites for invoking the statute? And finally, how extensive is the application of such a statute? The first disposes of the constitution, the second of jurisdiction, and the third of decrees or judgment. We can best answer these problems by considering the interpretations placed upon this and similar acts by the courts. So again, if there's a persona, it also is going to lead to in rem. So if there's a trustee, the trustee is in position of in rem because it has to deal with property. Y'all get what I'm saying? Okay, because persona, they're relating it to the trustee, and then they're relating it to the obligations of the trustee, meaning that the trustee is supposed to have a performance. Anytime there's equity, you're looking for performance. Okay, so that's why everything they relate to in persona, because they're trying to get the actual person, meaning the one who holding the title, to perform equity. All right, to perform. But sometimes the trustee can't perform based upon the equitable interest that the equitable owner has. If something is to be distributed to the beneficiary, then the trustee cannot what? The trustee cannot distribute it anywhere else. So that's why things are protected into the trust. Y'all see what I'm saying? Zeros if you're with me. It's real important that you get this. So constitutionally, the basis of all real equitable procedure in Pennsylvania is statutory. Yet the mere fact that this additional power has been given by statute does not make it valid. It has been the policy of our jurisprudence to bring non-residents within the jurisdiction of our courts only in very special cases. Commenting upon this policy, it was said in cause appeal, we may congratulate ourselves that such has been the policy, for nothing can be more unjust than to drag a man thousands of miles, perhaps from a distant state, in the effect compel him to appear and defend under penalty of perjury, on the penalty of a judgment or decree against him pro confesso. The Act of 1859 ought therefore to receive a construction in harmony with this policy. There seems no good reason why the courts of equity should be invested with a more enlarged jurisdiction against non-residents than courts of law. For a court to have jurisdiction over the person or property of an alien, either that person or his property must be within the territory. Listen what they're saying. Territory also means trust, guys. It's within their trust. Okay? Zeros if you with me. If it's not in a private trust, it's in a public charitable trust, which is meaning it belongs in the public charitable trust of the United States or one of the state of. All right? So, Chief Justice Gibson stated in Steele versus Smith that an exercise of jurisdiction out this presence of situs would be an act of usurpation. I mean, they usurping office, guys. Adding further that jurisdiction of property does not draw after its jurisdiction of the owner's person. Yeah, since the Act of 1859 purports to give courts jurisdiction over defendants, all or some who are without the territory, it must follow then, in the view of the aforestated principle, that the act depends for its validity upon the presence within the territory of some property or rest which forms the subject. I don't know what just happened. Anyway, which forms the subject matter of the suit and the object of the decree. That is precisely what the Supreme Court of the United States held in the leading case of Pinyard versus Neff, involving an Oregon statute comparable to ours. Said the court. Substitute service by publication or any other form may be sufficient to inform parties of the object of proceeding taken where property is brought under the control of the court by seizure or some equivalent act. The law assumes that property is always in possession of its what? Owners. Listen what they're saying. The law assumes. So that means that whoever is the holder, they're going to assume that you are the owner. Listen what they said. Assumes that the property is always in possession. So whoever is in possession, automatically you are assumed the owner. That's by good or bad. That's the law. Okay? Doesn't necessarily mean by equity when it comes down to the rightful owner by titles. Zeros if you with me. All right. So it says the law shows that property is always in the possession of its owner, in person, or by agent. So you either gonna be in person or by agent. And it proceeds upon the theory that its seizure will inform him not only that it is taken into custody of the court, but that he must look to any proceedings authorized by law upon such seizure for its condemnation and sale. So, sir, so this is literally what they're telling you. If they take your preceded vested estate and the proceeds, your securities and bonds that related to it, they got the right to what? Sell, which means they have the right to transfer and securitize them, right? All right, that's what they tell you. And this is going to compel you to come to court based upon this being your property. So such service may answer in all actions with substantially proceedings in what? Realm. So they like this. Look, if you make it personal, they just said you can't drag somebody all the way from a whole other jurisdiction about some property that ain't even in, within the jurisdiction in your territory, right? But if you get their property and you bring it into your territory, because they said they get the what? The law assumes that one who is in possession, listen what they're saying. The law assumes that one who is in possession is the owner, in person or by agent. So remember, they are agencies. So they are acting as agencies, acting in possession owners, right? At all times. Are y'all paying attention? Zeros if you with me. It's in your face right here. They showing you how they operate. So remember, anytime you make an assumption, you can make an ass out of you and me, right? Ain't that what they say? So pay attention to what they're saying. It said, but where the entire objection of the action is determined, the personal rights and obligations of defendants, that is where the suit is merely in persona. Constructive service in this form upon a non-resident is ineffectual for any purpose. Process from tribunals of one state cannot run into another state. All right. So think about when they say state, they talking about trust. Process from the tribunals of one trust cannot run into another trust. And some parties, they're domiciled to leave its territory, meaning that it can't leave its trust. All right. The parties are trustees of a trust. Can't serve two masters. And respond proceedings against them. Publication of process or notice within the state where the tribunal sits cannot create any greater obligation upon the non-residents to appear because they don't got no jurisdiction. Process sent to him out of the state and process published within it are equally unavailing the proceedings to establish his personal liability. So how do you get him to come forth? You start attacking the property, right? Think about it. How do you get the non-resident to come forth? Right. They don't have personal jurisdiction over you, right? So, but if they telling you that if they gain possession, so they basically saying, we're going to steal your shit and assume it's ours. By law, we have that right because we can assume it's abandoned until you come and claim it. Y'all ain't paying attention, man. It's y'all. Y'all ain't paying attention. Y'all ain't paying attention today. Better know, let me know you see it. So it says, in Bowen versus Bowen, the plaintiff wife filed a bill of equity against the defendant husband, a non-resident, complaining that he had deserted her and refused to support her. She invoked statutory remedies providing for service under the Act of 1859 against defendant's property in the county of the suit. All right. So it says, the court granted an order directing service on the defendant, calling for the entering of an appearance and the filing of an answer. Within the notice of failure to appear and answer would result in decree of pro confesso. Affidavit was filed stating that defendant had been served out of state. Appearance was entered for defendant David Nayese, and court was petitioned to set aside service. On the court's refusal, the defendant's appeal, the Supreme Court stated the acts of assembly authorizing a proceeding such as this one could not grant authority to a chancellor to require a defendant outside the jurisdiction of the court to appear and answer. The proceeding is one purely in rem. It may be proper to give defendant notice. He may ignore the notice if he likes. The proceeding will go ahead against any property of his within the jurisdiction which the court has taken within its grasp. Listen to what they said. They said they took it. Look at the word they choose to use. They said they take. So they took it. They took it. They say he may ignore it if he likes because they don't have personal jurisdiction over him. However, his property is over here close within our territory. We're going to assume it. We're going to assume. Are y'all listening to what they're saying? So it says the proceeding will go ahead against the property of his within the jurisdiction which the court has taken within its grasp. The court reversed the action of the lower court, remanding for disposition in rem. It is interesting to observe that after the lower court entered its decree in rem, defendant filed a bill in the United States court, watch this, for the Eastern District, seeking to enjoin the enforcement upon the decree upon the ground that it's effective to deprive him of property without due process of law. There again, he lost. The court, he lost. The court holding that under these precise Bowen cannot be heard to the object that he did not have the notice of proceeding, nor any opportunity to defend, because he did. He had the right to defend his property. But that's why I told y'all, it's about business. This wasn't personal. Personally, they don't. They don't got jurisdiction. But by business and his property, they do. Now y'all see what I'm saying? Yeah, let me know y'all with me. It's 130 some people in here. So I'm showing y'all why we go make our claim in rem. Why are we making claims and assigning interest? Because it's about the property. And we're going to always keep it about the property. Because if we make it about the property, then it's the owner is about the possession, right? So if we are holding the certificated security, what does that tell you? That should tell you everything. Why we are making our claim in rem, which means against the thing. Against what? The preceded vested estate. So you got to realize the preceded vested estate, meaning that it hasn't came, and the preceding vested estate is your children's inheritance, which is your estate. So you have to protect that now. And a right up interest in it right now. You see what I'm saying? So with that being said, you have to fully protect it. That's your interest. It's already been given to your children. Excuse me. Y'all follow? All right. So what conclusions then can we draw at this point? It appears certain, at least, the legislation of this character does encroach upon almost laissez-faire policy, of course, where non-residents are concerned. Now, the laissez-faire court meaning that if they basically find you without nationality and you so lawless, and that means that your property is not within the trust, then they got the right to assert their jurisdiction over it and use their statutes and codes to govern according. So, yet such an encroachment, so-called, is valid if held with recognized bounds. That is, if the court does not essay to entertain proceedings other than those directly affecting some rest conceiving within the court's territory jurisdiction. Our task now is to determine just when, how, and what types of action the court has this jurisdiction. So now let's talk about jurisdiction. Jurisdiction is studying the phraseology of the statute. We see that the legislature start out with the broad general statement that it shall be lawful in any suit in equity. The latitude of this beginning, however, is restricted by modifying clause, which limits any suit to 4 specific classes of cases. All right, concerning goods, chattels, lands, tenements, or hereditaments, for the perpetuating of testimony concerning the same, and concerning any charge, lien, judgment, mortgage, or encumbrance on the same, and where the court has acquired jurisdiction of the subject matter meaning property, trust, rest, in controversy by serving one or more of the principal defendants. Still further are these first 3 classes of cases modified provision that the rest must be situated within the court's jurisdiction, and a comparable provision limits the 4th class to those cases where the subject matter can be brought within the jurisdiction by personal service on a principal defendant. All right, so where the property was a dam extending partly into the adjoining county, the court refused relief because the property was not situated within the jurisdiction. Okay, the court held that a mortgage is personal property and therefore governed by the principal mobilius sequential persona. I guess that's how you said it. But movables follow the person. That's what it means. So, hence, can be reached only where the mortgage creditor is. All right. Who's the mortgage creditor? You are. And still another interesting case. The plaintiff administrator filed a bill in equity in Philadelphia County, okay, averring that a few days before, the defendant, by fraud and undue influence, had embellished plaintiff into transferring to defendant an account in the Savings Fund Society of Philadelphia, 589 shares of stock, United Gas Improving Company and Mortgage of Philadelphia premises. Defendant resided in Morgan County, and the bill was served there under the Act of 1859. At the time of service, the title papers, evidence, ownership of the property were in the actual possession of the defendant. The court held that the bank account, mortgage, and stock certificate were not within the jurisdiction, being personal property, and hence follow the domicile of the owner. However, the court indicated, and properly so, that the subject matter might be brought into the jurisdiction by personal service on the principal defendant. In connection with this, it was held the Lebanon Valley Consolidated Water Supply Company versus Commonwealth that the act does not, in action to compel delivery of bonds secured by a mortgage on lands in the county where instituted warrant service on the defendant in a different county. All right. So that means just because they did it in one don't mean they had the power to do it in another, because that property does not reside in that territory or jurisdiction, is what they're saying. Got it? Everybody get it? Got it? Good. Okay. So a still further question arises from the mere reading of the statute, namely, what is meant by principal defendant. Some cases have turned on this very proposition. Although the courts couch their definition in very general terms, making it necessary to decide each case on its own facts, it might be well to observe what it is said. Every case considering this issue has quoted what approval? The following excerpt from Joy versus Words. Oh, I hear your fault. It was mine. I hear vibration. All right. So in deciding who ought to be parties, it is necessary to distinguish between active and passive parties, between those who are so necessarily involved in the subject and controversy and the relief sought for, that no decree can be made without their being before the court in such as formal or far passive, and that complete relief can be afforded to those who seek it without affecting the rights of those who are omitted. All right, so in Whitaker versus Miller, the Supreme Court stated, if such unincorporated association may be dissolved and its assets distributed to those entitled thereto without the joining of the William Cup as defendant, he is not a principal defendant with the scope of Act of 1859. It appears that William Cup, the treasurer, has no more control over the affairs of the unincorporated association than any other member thereof, that his duties are ministerial only. Up to this point, we have seen that the general requisites for jurisdiction under this act are a rest, and that rest must be within court's jurisdiction or brought within it a particular manner. Further, that the suit must concern that rest, it is on this very requisite that the fate of act hangs by their interpretation. The courts may or may not render the statute abortive for all practical purposes. So basically what they're saying is this. Okay, let's say I just walk up and I go and make a claim in the court about some property, and I create titles and everything like that, and I go and make a claim, and you decide that you're going to ignore it. And remember, based up, the law is going to go with based upon the assumption of the possession of ownership of the person. All right. So if I go and make a claim and I show that I have a title, etc., and this could be a color title, it could not be the actual real title, because you might have something showing that shows a bill of sale that leads to your title, and I don't. Okay. And so let's say I make that claim and you don't show up. Well, guess whose favor they're going to rule in? Put it in the chat. Whose favor are they going to rule in? Absolutely. They're going to rule in my favor, even though the property ain't mine. Right? Okay. So now imagine the Native American so-called, or the indigenous people here, and they like, hey, and the Europeans show up, and they like, we finna buy some land. They basically like, sell us some land. They want to buy some land. And the indigenous like laughing because they like, aha, you know, I didn't know you can own land. But hey, if you want to buy it, here you go. And hey, you want to buy this water too? Do you want to buy this? Do you want, you know, it was kind of like a joke because nobody owned anything. No matter how much we want to say we own this land, we don't. We all are in use of it. Nobody has no power over this land than any other being. It's not. It's not. You know what I'm saying? We don't. And people want to control people for forms of resources and so called of ego stroking for power type thing. But other than that, this could be a very peaceful place just upon using the natural resources that are here. And that if we all wasn't so packed in the city like sardines and scattered abroad and growing and doing everything, then there would be no harm. That's not what's going on. People take works in the fashion and all this old crap and, you know, whatever. And they make all this type of disputing between different things. So, you know, and now you have what you call different classes and all that. But classes put people in poverty because there is a class. There's a high class and a low class. So somebody has to be impoverished through this system because of you set a class. So there has to be somewhere where people filter into their class based upon ignorance. Y'all follow what I'm saying? Like, this is really just knowing what's up. Okay? Really knowing what's up. So I'm not going to keep going into reading in this, but I just wanted to show you guys like why we are moving in Rem. So if you notice the claims that I've been making with the executive letter, right? All right. You guys remember the executive letter. And this is what we're saying. We're making our claim in Rem. Okay? Our claim is absolutely in Rem. It's an action in Rem because it's an action against the preceded, vested, landed state. Okay? And the preceded, vested, landed estate, that's like a form of future interest and also a present interest because it's a life estate. So you have an interest in it now because you are in use of it. But you also have a the future use of it based upon you being able to transfer that to your what you call beneficiaries, as you would say. Okay. Long as you have a place for the property to go, then it's always in use. I don't care if it's sitting in the bank. As long as it has a plan, then it's in use. You know what I'm saying? It's just how you do it. You can have money sitting in the bank that can't be taxed based upon you already have a plan for it in use based upon some non-taxable situation, whether it's educational, charitable, or religious. It's just about what you say. Then that puts everything automatically in a trust situation. It's something that has been set aside for a special, purpose. It's funds, which is considered to also be a special deposit. So we make things in Rem. So again, we are making our claim against the actual preceded estate. All right. That's what we got to make our claim against. And we know that that everything is operating in commerce. So if everything is operating according to the UCC, then everyone is merchants. All municipalities are merchants. The states are merchants. The United States is a merchant as well. If everybody fully understand and understand that, because if you guys are here, then you are saying you're probably one of the ones that's screaming, hey, the United States is a corporation. Well, the United States is a corporation. Who are the shareholders? Okay. And if we are the shareholders of this corporation, that makes us the investors. And as the investors, now that makes us have control of this corporation resources. And its resources is the U.S. citizen. Okay. And all of the debt the U.S. citizen acquires that becomes liquid assets. So you guys have to truly understand the elements of life. You have fire, you have water, okay, you have wind. All right, fire, water, wind, and that's it, wind, earth, excuse me, and earth. And then the fifth one is spirit. Okay, it's spirit. So those 5 things, absolutely. All right, and it has to be. Spirit is definitely an element of life. If you don't think spirit is, then you're definitely gonna miss how this everything is transpired. All right, so what you have to realize in this place, then, so you have to realize we're taking property. Property is considered solid. Everything is coming from earth, right? So we're taking property. Property is that form of earth, so to say. So what we're going to do is liquidate it. How do we liquidate property? How do we turn something that's solid into its liquid form? And the only way to do this is by monetization. So that means we have to turn a property and liquidate it. That means we have to turn it into a value of consideration. So we have to give it a what? We have to give it a value. So now we just liquidated something that was in a solid form. Do y'all see what I'm doing? Do y'all understand? There's nothing above the natural law. It can be explained like this to our children, and it's that simple. And once you teach them the natural elements of life, then everything else works the same. Everything else is built on top of that, no matter what. Anything that goes against that is chaotic. It'll never work. So with that being said, this is what we're doing. Okay? So when you do this, when you liquidate something, right? And then once you get something of liquid and you get the turning liquid, right? And this liquid has a form of a way to channel in a certain way. This liquid turns into what they call energy. Are y'all listening? That's what dams produce, right? That's why we got dams and stuff all in these cities and stuff, right? They're producing a form of energy, right? Need to make sure you guys understand what we're saying here so you can understand what's happening. So we turn it into a form of currency, and currency has to flow. So let's check this out. So this is what we call a form of transmitted utility. So let's pay attention to what we're saying. What is a transmitted utility? So transmitted utility, according to UCC 9-102, drop down to 81, definition transmitted utility. So transmitted utility means any person primarily engaged in the business of operating a railroad, subway, streetway, or trolley bus, transmitting communications electrically, electromagnetically, or by light, or transmitting goods by pipeline or sewer. So look, transmitting goods by pipeline or sewer, or transmitting or producing, transmitting electricity, steam, gas, or water. So what are we doing? We're transmitting goods by pipeline. So now everybody like, what's pipeline? So let's look at pipeline. Pipeline is the flow a deal makes through clients, banks, and firms. So remember, everybody is a bank no matter what, because we all are able out here to, we're all acting as bankers, whether a private banker or a public banker. Okay, everybody is accessing into receiving money, lending money, sales and exchange, stuff like that. That's a form of banking. Anytime you got some form of account, there is a form of banking. Okay, so this is the flow and deal that makes through banks. That's a pipeline. Y'all paying attention? Are you paying attention? Are you paying attention? Okay. So, and then, of course, Article 9 definitely deals with securities. So securities are being transmuted. That is the goods, securities, funds, credit, stocks is equivalent to cash. All of these things are equivalent to cash. And they're being what? Transmuted by electronic transwire, by mail, whatever the flow is to the pipeline from you to the bank. Whether it's somebody sending you a check through mail, whether it's whatever, that is considered the pipeline. It is the flow. Okay? You guys understand what I'm saying? Zeros if you with me. Who all just learned something new so far? Say me. Say me if you learned something new.
Me.
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 I
Definitely.
know that's real. All right, so watch this. Watch this right here. Because now we finna get talking. So again, this brings us to the certificated security, conveyance and certificated security. All right, this is claiming ownership of the birth certificate, right, as a real estate. Some people still don't believe this is possible, but it's in your face. It's already been done. It is done. So with that being said, the preceding vested estate, this is what we are talking about. This is the first thing that we have interest in. This is the property. This is why our claim will always be in rem, is because of the birth certificate, which is a certificated security to show that you are a shareholder of the United States and you have all rights and interests to its natural resource, which is the private individual franchise entity that it gave you. Zeros if you with me. So I've already claimed interest, guys. I've already claimed interest. This is $200 million. I've already claimed the interest. This is a $200 million asset. Just to even touch it, it's going to cost you $200 million. That means if something was to happen to me, my children they can already kick out $200 million. They can take this whole entire specific conveyance and send it out to the treasury, and they're going to get kicked out $200 million off the rip. That's simple. But that's another day. So you guys know how to go. You can learn how to do this, but then now you got to learn how to make sure that you cash out. And yes, it is definitely life insurance, not insurance, assurance. And you said that correctly. So with that being said, that's what I'm speaking on. All right, so now let's jump into this. So again, we make our claim. I didn't know if I was gonna do this for y'all tonight, but I'm gonna do it for y'all tonight. We're going hard, go hard or go home. Just to go hard or go home month. This last month. So we go hard or go home. So with that being said, again, you know the executive letter. This is us making our claim. Okay, over the preceded vested land of the state, and we're letting them fully know. Now, let's go down to the part where everybody's having the part where it matters, what we're assigning interest, because everything is about claiming and assigning interest. We already got control of the preceded vested land of the state. That means anything that has this name on it, we have interest in whatever it is, wherever it's at. So that's why, again, if they send you a letter about your all caps name, it says the city of such and such versus your all caps, you have to go, because they just took control of your property, and they're going to assume, based on them having possession of it right now, that they are the ones who get to adjudicate and they are the owners of it. We just read that, correct? So now you see why you have to answer, right? Everybody? You see why you have to answer. You have to do something. It's a must. Nobody can sit back and not do nothing. Nobody. Okay? Keep that in mind. So what we saying right here, We're saying this matter creates a constructive trust by you taking religious private property of the preceded vested land of the state within the jurisdiction of the living trust and using it in the public to settle the public interest without just compensation to the living trust, equitable owners, and the people of Morris National Republic of Peace. Based on your actions, you now fully agree to be governed under the Constitution of Morris National Republic of Peace. And the reason why is because that is what governs the actual trust. Okay? Those laws govern the trust. Okay? Whereas I now accept all securities in equity as redemption. We're going to accept them. I accept all charges on the accounts. I am releasing, assigning all interest, and transferring all chattel papers and securities of the principal debtor given for patent rights. Giving for patent rights. Key word, give. So we gave. And we gave patent rights. That means we gave interest in something that was of our creation, right? And assigning Leanne Landis in her ex officio capacity because she's a private contractor for the merchant. Okay, she contracts for a merchant, which is the city of Sheffield. Okay, so what that means is that she's out here being able, they hire her to be able to contract and do business for them, right? Okay, and now that means that she is a fiduciary to settle charges within the public and private of this mutual account immediately. Any misuse of the trust is a breach. Trust rest is a breach of trust. So now, everybody always been asking me about the UCC one and the financial statement and how do we file and all that. So we're gonna do that today. Y'all think we should do that today? Do y'all think we should do that today?
Yes.
Now, the only way we gonna get to do this today, I'm gonna ask a question. And y'all gotta follow the directions. So that means you got to raise your hand. Nobody can butt in. But I'm gonna ask a question, and this is gonna determine on it. Whoever I call on is gonna be determined whether y'all can show this tonight. So, and I'm saying this because I don't want to show you this based upon you just something to do. I want you to when everybody in there comes in my class, I want you to know how and to know why. Because if you know the how and why, you're going to be able to do this no matter what, no matter where you at, no matter what situation you in. You ain't got to call nobody and say, what do I do? You know how, you know why. You know the power that you have. You know how to grab a napkin, a piece of paper right then and there and write what it is that you need to do to claim your interest. That's the type of power that I want you to have. But that's gonna be directly determined on you. So with that being said, the question I want to ask is, why are we claiming and assigning interest? Why are we claiming and assigning interest? Y'all get 3 tries. You get a lifeline. If you want some help and you know somebody you want to call on, you have to call on that particular person to help you. All right, you ready? A G thing, you got the flow. Come on forward. Can you hear us, a G thing? A mic ain't unmute. All right, we might have to try it again then. Who you say was next? All right, Amin Wilton.
Yeah. Is my mic? Can you guys hear me?
Yeah, you on the floor.
Okay. To claim the interest, the reason you claim interest is because it's all taxable as property. If you hold it, you have a fiduciary responsibility for it. So you have to transfer it back to the corporation so that they can cover the debt and obligations of it. That's from my understanding from reading and listening.
Okay. Anybody else? Anybody else? I ain't saying it was wrong or right, so don't feel like your answer was wrong. But anybody else? All right, who you want to get? Mario Ford. Mario Ford, come forward. Mario Ford. Mario Ford. Y'all guys got to learn how to unmute your mic. Just hit the mic button. I know some of y'all probably don't work though, because this time we'll be tripping. So if it don't, then go in and come back out. Like go out and come back in. Excuse me. All right, Shay Johnson, what's happening? Talk to me. I know Shay.
Okay, can y'all hear me? Can you guys hear me? Okay.
Yeah.
So I'm gonna give it a try. So we're claiming the property as an asset on our books. So that way, once we make it trust property, we get to assign the interest in the property, but we can't do that until we make it an asset on our books.
That's a good answer too. All right. We got one more answer. Good answer though. Both of y'all. All right, Q. Q. What you gonna do?
Man, don't me like that. Now you making me nervous. Nah, I agree with the last two people said. You know what I'm saying? But I know you also want to accept all charges to release them back to them. So basically you release the liability because you're putting them in a fiduciary position so they can basically offset or handle all the debts because you're assigning them fiduciary responsibility with trust property now. I hope that was enough with what the other two people said.
All right, that's a good answer. All right, G thing, you got one more time. Can you click in? It's gonna let you in.
I think I'm in. Can y'all hear me?
Yeah, go ahead.
Yeah.
Okay. We are making a claim and assigning interest because we are the holder in due course of the property, I guess we would say. So they created the debt, therefore they own the debt, but we control it because we have possession of it. So since they created the debt, they own the debt. That means we obviously own the credit since we are entitled to equitable interest. So we just are balancing the books as the previous people stated.
All right, so everybody has a great answer. And I'm going to help simplify this even more for you guys. So the thing is this. Always remember who you are. And I'm saying this because I want you to know what happened and what got us in this place in the first place. All right. So we know they went bankrupt. And by them going bankrupt, it caused an involuntary contribution. Okay. And that literally means that they didn't give the people a way to pay a debt. So since they didn't give people the way to pay a debt, this causes a secondary involuntary contribution. Okay. But you have to cure the primary involuntary contribution before you can secure the secondary voluntary contribution, right? So the first is the fact that we have to give the United States something, right? In order for them to settle the debt. So in order for that to happen, all credit was given to the people. Well, in order for credit to be what was given to the people, that means that the people had the power to claim assets. That's our credit, because we give things credit by giving it what? Value and consideration. So if we give promissory notes value and consideration, it turns it into a liquid asset. There is no debt. That simplify that for you guys. Now y'all understand why we're doing what we're doing? For the people that answer.
Yes, much clearer, much clearer.
Yes.
Yes.
Makes sense. Yes, sir.
All right, so that's good enough to get y'all to the next level. That's good enough to get y'all to the next level. Y'all passed. All right, so let's jump in it. The UCC 1 is a financing statement. Okay? Financing statement. So with that being said, we just agreed that we are the financiers of the United States, right? Ain't that what we just all said?
Yep.
Everybody that answered said the same thing, that we're financing. So we are the financer. That means that we also, any corporation that created by them is also bankrupt. So we finance those corporations, municipalities, and any creature of it, which also means the U.S. citizen, which we have taken control of within our jurisdiction, within our trust, so to say, as we are the holder in due course, because what? We have control of the natural resource of the United States. So what's the United States natural resource again, family?
People, energy, labor.
Energy, like y'all.
No, it's not people.
Citizens.
It's the U.S. citizen.
The citizen.
Not
Citizen, that's right. Yeah.
Exactly. They did not create you. Okay, so it's never the people. That's not they did not naturally create you. What they naturally created was a U.S. citizen. That's it. They ain't create nothing else, just U.S. citizen. So anything that they chartered or gave birth to, such as your franchise individual entity, which is a U.S. person. Okay, one corporation can give birth to another corporation by subsidiary corporations. See how I did that? Which also creates a subsidiary trust. So a mother creates a subsidiary trust when she has a child, because everything that she do or everything that she acquired is going to what? Transfer to the child by inheritance, correct? Which is in the subsidiary trust. This is a continuation through the bloodline of a family. Y'all understand, overstand, and understand what I'm saying? Very important that you know that. So we want the acknowledgement. We want the acknowledgement sent back to ourselves. What is the organization? The debtor is the organization name. So we're going to use the city. Okay. City of Sheffield is a municipality. It's a debtor. Then we're using the who did we give interest to, guys? Who did we give interest to? We gave interest to Landis Lay Ann. So she's a debtor because she's the private contractor. All right. Now, what are we claiming? Well, we claiming the account bond number, all interest in chattel papers and security of the preceded vested land of the state, which brings us to this. So I'll show y'all this. Got to show you guys this. So I've already showed it to you once, but I'm going to show it to you again. All right. So here we are. Here is the conveyance of property. Okay. Like we claim. We claim this account. I'll enjoy this proceed, title, bonds, chattel paper securities at the value and consideration of $200,000. All right. And we claim this. We also now we turn around and did the what? A title to it. So we the only one with a claim. There's nobody else with a claim to it. So that is the reason why I can come over here and do what I'm doing. Okay? So all interest, chattel papers, and security of the preceded vested land of the state. Now, again, drop down. If we was dealing with let's say if we was dealing with the actual state or some form of government, then it would be a public finance transaction. Okay, but it's a municipality and they're not considered a government unit. So now it is a transmitting utility. All right, and that's what they're gonna do. They are transmitting utility to us. They're transmitting interest to you. Okay, through a pipeline, which is a flow. Did they not put a claim in the mail to you? Huh? Did they not put a claim in the mail to you guys? Come on, think about it.
Yes.
Did they?
They send you a bill.
So is that not considered the pipeline? Huh? That's the pipeline, right?
Yep.
So if that's the pipeline, that brings us to the situation of what now? That creates them as debtor as a transmitted utility, right? They're sending us our interest related to the property, right? And they saying they have taken this property they assume this property in their control. So now I'm claiming my interest on it. Oh, y'all created a constructive trust? Bet. I'm the secured party creditor here because I'm the one holding the preceded vested land estate. And I can show it. Optional file of reference dated. Recorded in Carver County, Alabama, book 2023, page 383, 384, and 385 at 02, February the 21st, 2023 at 11:46 a.m. So look at that. At that time alone, now all they got to go do is what they're going to run into is this. They're going to run into the certificated security. So when they run into the certificated security, now they're going to go and read this and say, oh, shit. That's the first thing they're going to say. Oh, we don't need to mess with this. We don't need to do that. Because this guy has the interest, and it's $200 million of messing with any property that's related to this preceded vested land of the state off the rip. Okay? So now we let them know that. Now that we claim the interest, this is claiming. Okay? We claimed it. Now what we got to do, guys? Just claimed it. What we got to do next? Put it in the chat. What we got to do?
Transfer. Yeah.
We have to assign. So now we assign on UCC3. I'm showing y'all how simple this is.
All right.
So now we click on assignment. Make sure you put the filer number up here or not, just leave it blank and just send them both together and they'll make sure both of the numbers are filed the same when they send it back to you. But with that being said, if you do it online, it's going to automatically do it for you. So with that being said, you click on assignment, you drop down, and you're going to put the, right here it says complete for assignment party. So now, what are we doing, guys? What are we doing? If we're assigning, I want you to think about we are forgiving our debtor. Forgive our debts as we forgive our debtors. So what we are doing is we're giving them interest. We're redeeming him. We're bringing Lazarus to life. Lazarus was dead. We came to Lazarus and assigned him interest. When we assign interest, we give the dead energy. We bring it to life. Are you guys understanding, overstanding that? Might be a little complicated for those of you who's not really that spiritual, but I'm just helping you guys that are out. Okay? This is exactly what we're doing. So now we assign interest. We assign it, assign the collateral, assign the city of Sheffield. Now we assigning all interest. And then you can just put your little statement there. I am releasing, assigning all interests, and transferring all chattel papers and securities of the preceded vested land of the state given for patent rights, and assigning Leanne Landis in the ex officio capacity, private contractor for the merchant, city of Sheffield, put their DUNS number as fiduciary to settle charges within the public and private of this mutual account immediately. Any misuse of the Air Jamar Ingham Bay Living Trust Rest is a breach of trust. Woo! Y'all don't understand what's being, like, y'all don't understand what's going down. Secure party right here. Myself, and I can prove on the secure party because all they got to go do is look at what? I am the equitable owner with equitable interest. So I am the secure party. I'm the holder. And go look at this and find that out, which is why I made reference to it, right? All right, now, that's just one debtor. We got to add the other debtor. So now you got to get the AP, which is the UCC3 AP, which is adding the additional party. So let's add the additional party. Again, this is a surname that authorized this assignment. There you go. Write the judge's name, individual surname, etc. This is the living. For those of you who don't know, I'm going to show you. I'm going to show you it's the living. Let's go down here and look into, let me see. Is it this one? It's in the first one. Let's go down here and look into it. What it mean by individual. Individual name means the name of a natural person. This includes the name of individual doing business as a sole proprietorship, whether or not operating under a trust name. The term includes the name of a decedent where collateral is being administered by a personal representative of the decedent. The term does not include the name of the entity, even if it contains a part of the entity's name. The name of an individual. All right, prefixes such as Mr., Mrs., and titles are generally not part of the individual name. Indication of lineage, not a part of the individual name, but may be entered into the suffix box. So they let you know the individual debtor name. This can constate of the actual living. All right. So again, we just dropped down over here, got her name down fully as a debtor name. All right. And again, I am releasing and assigning all interest and transferring all chattel papers and security of the preceding vested land of the state given for patent rights, and assigning them for private contractor for the merchant, city of Sheffield. And there we go. This is done. So I file it. And as you can see right here at the bottom, it says International Association of Commercial Administrators. This is international, because I told you, anytime you make a claim in rem, it is against the whole entire world. Zeros if you with me. Now, what I just showed you guys ought to speed your guys' process up with the executive letter. So, and the thing is, if you understand the executive letter, then you're going to know how to come over here on the financing statement and make your claim, because you are the one that claimed it and you are the one that have to assign it, which makes you the secure party. They have an assumption. You actually made a claim. Are y'all guys hearing what I'm saying? All right. So we're going to open the floor for some questions. Let's get some hands raised and let's talk about it. Brother Leon Gordon. I'm sorry, Lenore Gordon. Please forgive me. Ooh, my baby, I get up. Lenore Gordon. I wouldn't have answered either, sweetheart. I promise you I wouldn't have. You can unmute your mic. All right, we'll come back to you. Go ahead, Trust Living.
Yes, when we do the UCC one, I was doing some studying and had saw that it's considered like, because I know that we are also claiming that we're not at war with the United States. And I've seen it where they say that when you do the UCC one, now you go into moving into the direction of mixed war. What is that? Are you familiar with that?
It's bullshit.
Okay. Okay. Is that why we do the non-UCC instead of the actual?
Nah, I'm doing the whole
UCC?
UCC. I'm not doing the non-UCC because we making our claims according to commercial codes. So if you making your claims according to the UCC, then you're supposed to make it a UCC. File it. You're telling them to honor everything according to UCC. If you take it out non-UCC, then it's gonna deal on special private relations. But I'm bringing everything according to the UCC because that's how it's stepping in anyway. Is according to the UCC. Remember, we're merchants, so if we're gonna be merchants, let's operate according to the UCC. I gave a tender of payment, which was a form of promissory note. So let's say if this was a bank we're dealing with, all right. So I would make a claim on the actual account and note and all enjoyments, right? Simply because that is my collateral. I'm the one who financed the whole entire situation. So, and they got a copy of it. So once I claim interest and assign it to them, because they are the holders of it now. So if you want to be the holders of it, then you also responsible for the liability of it. Do you understand what I'm saying?
Yeah, that makes a lot of sense. I was just curious as to when you do the public side of the UCC, whether it compromises the private side.
No, because
Since
what you
most of our
already did was you already went, but it's already public. Think about it. Listen, everything is already made public on a simple fact because all of these companies that you're pretty much dealing with usually got an SEC filing, which means they're public. And they're telling that publicly how they're going to deal with securities and everything that like that, right? Okay.
Mm-hmm.
Can y'all, everybody hear me? Have I been breaking up to you guys? Everybody hear me loud and clear? I'm pretty sure if I would, y'all would tell me. But
yes,
some of you guys might be in a bad
you coming in.
signal. Okay. All right. So long as I'm coming in clear. So with that being said, you know, it's just like you are the one that financed it. You have to make claim of interest, but we have to redeem them. That was the deal. The deal was that we don't sue them for not having money. The deal was that we're not going to make them remain as debtors. The deal was that we were going to give the securities to them so that they can, you know, have our obligations. That's the deal. So we have to honor the deal.
So then if we were deeming them based upon, I think it's called a certificate of indebtedness, which is the presentment, which is a security that matures in 9 months that we accept for value. And like you said, assigned to them, which is the interest, right? Based upon which is that tax interest that basically we've earned on that account, then are we ever getting our hands on that interest that belongs to us? Or are you saying we simply just balancing the account from the interest that remains on the account after they've used the credits?
It's balanced though, and you got to make your claim. I showed y'all the tax forms the other day. So is this not a gift?
Right. And that's the 706 where when we file the 706, that's where we get the recoupment. That's where we get to claim our recoupment.
The 706 deals with the estate. The 709 deals with the actual preceding invested landed estate. That means your lot you're living. 706 is for the decedent. That means that anybody that you're dealing with for the decedent estate. I'm not deceased, and you ain't either. And as long as you constantly giving life to this actual estate or franchise or person, it's constantly alive. You understand what I'm saying?
Yes. So then it will be the 709 along with the, I believe it was the 1089A, and then it was another form, 56F, that all of that will go together when filing for that tax recoupment.
If that's how you choose to want to claim, then yes.
Okay.
It's
Okay,
just you
so that's
making
another
your
way
claim.
Okay, got it. Thank you.
Alrighty, peace, love, and law, family. For those of you that don't know, that is a rerun of season 2 work session, and pretty much everything that you've seen there has happened for sure, right? So, just want you guys to know that. But we definitely appreciate you guys listening in on that. So, what do you guys think about what you just heard at this particular time? And anybody got any other form of questions as well? Please let me know. Let me know. All right, please let me know something. But with that being said, let me get you guys about to show you guys something here in a second. Yeah, let me show you something. I'm gonna show you here in just a second, y'all. Drop some ones. Let me know you with me right now. Yeah, drop some ones for us. I told you we're going to keep this content dropping for you guys. So make sure you like, share, and subscribe. We always doing this throughout the day. Either you'll hear me live or you'll be hearing something that we have done once before. And either way it go, man, it's all great, successful information for you that we have had great success on for a long time now. And so so I just want you guys to be aware of that and know that we not playing. We is not playing. All right. Yes. Love this beat. All right. So, with everything that you heard, man, that's in season 2. So imagine we are in season 5 right now, and the growth from there to here. And trust me, that still exists today. What I just showed you guys about a lot of different stuff that you haven't seen yet, and I'm gonna show you though. I'm gonna show you it's still there. It's still there. So, just so you guys can do your own search. Oh man, they said y'all got inactivity on TikTok, man. Why y'all ain't showing no love, man? Come on. Don't do me like that. Inactivity. What y'all got going over there? They say when they get quiet, that's when you need to go check on everybody. All right, so let's see what I can find. Let's see. Because I'm about to show you guys. They say y'all been going. Man, you know how they do, man. It is what it is, though. All right, so let me see. Go to the search for you guys. Da-da-da-da-da. Yeah, we about to pull this up for you guys. Why is tripping? I didn't ask for this. I asked for the records, buddy. y'all just vibe for a second while I find this. Got smoke break on the beat. Service swag. Thank you.
Lord know my pain, he know what I've been through. How I roll my weed just to see it all through. How the people was doubt me, now they trying to get a clue. Expecting my fashion when the sauce come through. Never peep my mind because you worry about the shoes. Never hearing they lies cause you worry about the ride. Like, yeah, I know she fine, she got no heart inside. Asking questions to heaven, out here searching for blessings. Dropping ass to cash, trying to run up a credit score. The money show character, but y'all ignore it though. No chess, this poker. The life I was dealt, I gotta play it to the end. I give a fuck how they felt. From trust, love, to respect, we never gonna question that.
Yeah.
Loyal till a lie, so we on the same quest. Come sit in my classroom, you can learn a few things. Like we create the money while we chasing these dreams.
All right, let me see. I just about find what I'm looking for. I just about found what I'm looking for. Thought I did anyway. I'll show it to you this way. All right. Let me show y'all. Just so you know that I'm not playing with what I just showed you. You see this? City of Sheffield, Eric Ingram Bay, City of Sheffield, Landis. Yes. So when I click on this, you see what happens. There's a debtors on the secure party. This was done 2023, April. Still active. Right? So I just want you to know everything I just showed you, I meant it. And I have definitely done it myself. Just so you will know that. Okay? So what you was looking at is it was real. It's not something that you guys can be like, oh, that's it. No. It's for real. Straight up. Just like I was looking at those papers a while ago about the conveyance of certificated security. It's real. It's not something fake. Just so you guys can see that it's real. So the real question is, what are you going to do for yourself when it comes to you protecting yourself, your rights, your interests? As I always say, how this is set up, you know? And a lot of you do need to understand that. Okay? So now somebody said, there's a lot of questions, bro, and there's a lot to explain. And I think if you hadn't been here at the beginning of the video, then you might want to go back and watch it because I'm going to leave this up. So I did explain fully how to file the UCC as well. So, but just, I mean, you know, it's all in there. But I just really want y'all to know, like, you know, it's a blessing to be in this time right now and to do the things that we are doing, right? Being able to have the knowledge and then act on it. And, you know, a lot of it, I just, you know, I still feel like that's not even enough because who am I? You know, I feel like there's something greater than me that, excuse me, that's a greater force that's here and in control of everything that's, you know, happening by the will of, you know, myself. And what I mean by that is the choice and decisions where I choose to place energy. Then this particular force in nature will serve me based upon what I choose. You know? And that's where you have to be able to accept full accountability for everything yourself, you know, all of it. And That's just real, yo. That's real. Additionally, how should I address involving any necessary third parties to ensure the claim is enforceable and comprehensive? Well, see, that's why you got to come to this class, private administration, because I'm going to show you about the UCC. I'm going to literally show you a full private administration to where you have a secured interest to make the claim, right? Because of what you're going to be able to do. And after you get done doing everything that you're supposed to do by making your notice of claim, and then you doing your notice of dishonor and everything with the notary and a notary protest, and then a certificate of I forgot what it's called, right? Just right off the bat. But anyway, it's just everything, the whole process, what you do with the notary. And then now you're able to go and take remedy, whether you want to do injunctions or declaratory judgments. You can do liens and then go start doing garnishment, foreclosures. It's just a process. But at the same time, you're able to do it. And that's why I always tell people, like, when banks try to foreclose on you, foreclose on them. I mean, they got to answer to certain things too. And you can definitely foreclose on the note for sure, just by their failure to fulfill their obligations. So do understand that. So just wanted to put that out there to you guys today. I hope you guys enjoyed it this tonight. So any other questions? You said, what else? It's something about the trust. must the claim be managed under a trust and is required to secure the claim with gold or silver backing? Like, listen, man. Y'all got to understand one thing. Like, the Treasury is just where we lay out all the claims at when it comes to anything. You know what I'm saying? Like, that's where the places, that's where everything comes to money. That's where you're identifying the base of transactions for the part of taxation, whether taxation happens or not. That's another thing. So when we talk about claims, I don't know what you mean. Has the UCC been updated since then? You gotta clarify that a little bit more. But when we talk about certain things, like when it comes to trust and stuff like that, like if you're gonna do a non-UCC, that means that it's being handled and all records are privately kept somewhere, as in trust. And as if the whole administration was as of interest. And that's cool. You can do it that way. Or you can treat everything like it's in a part of business and in the commercial realm. Either way it goes, they have to answer. If they don't answer, then that's on them. But we are in commerce here, and no one can deny that. I don't care what you do. Everything has some type of monetary value in all transactions in the relation to the United States. That's just a fact, because the entity you have is considered by default. It is literally considered self-employed. So I want you to think about that from the jump. You are considered self-employed right now. Which also means that if you have a driver's license, it means that you are a self-employed driver for hire, which is why the statutory codes apply to you when it comes to driving. Because now they think you are in a commerce and driving in the commercial world because you are a self-employed for hire driver, right? You got to know that. And if you don't know that, then you're going to definitely misunderstand the system. You also have to know that they had to create this entity because they went and started dealing with commercial paper. And since they're dealing with commercial paper, Now they have to deal with the people in a commercial level, which means now the United States deal with the people through private contracting. If you don't believe me, every agency you go to try to get benefits, you have to fill out a contract. And that's a fact. And they all are dealing with you on monetary funds or monetary value. And then it's also dealing with you on the fact that any form of penal sums or whatever, it's all based upon a security asset, right? Financial asset. Now, you also have to understand anything that is in relation to the government is always securitized, and everything is securitized and sent to the International Monetary Fund. And the IMF has everything to do with centralized banking being able to run throughout countries. It's a fact. And you got to understand the game. So now that since we know the situation and we are contracting here, anything that we're doing with the government is through contracts. So now we place everything into commerce. Who are you in this particular level? So you have to understand that now we have to look at ourselves as master merchants. And what I mean by that is, well, whether you want to consider it or not, let's just look at it like the old days or the slavery days, right? So let's just look at it like the individual entity that you have, that they gave you, this U.S. citizen, it's your slave. All right? It's your slave. You're the master. Slaves must obey their earthly masters, which means all corporations have to obey the people, the earthly master, the one who created. All right? So now, what has to happen here is the earthly master, which is yourself, you're full responsible and liable for this particular entity to operate in commerce with this particular corporation, which calls itself a government, which it is a government because it still governs its property and et cetera within the territory. So it does has the right to call itself a government, as McDonald's is a government because it governs within its territory of its employees, and employees are like citizens of McDonald's. Seriously. It's all the same. So I don't care how you look at it. So now, since we know that we are in business, and now we have to look at it like, okay, we are investors in a corporation now because we're investing time, energy, and labor. Now, this investment here makes us shareholders. So we were given a certificate and a number to a slave. Now, as merchants here, we go out and we can contract. But when we go contract with a debtor nation, a debtor country already, well, here's the thing. They always they need you to give them something in order for them to create. Okay? That's what you got to understand. All right, so now they want you to give them something that we take into value and interest. And whatever that is, they have the right to liquidate that. So we're monetizing everything into its currency. So far as like right now, they're monetizing our videos right now. They'll tell you, hey, you're going to get paid because ads is being ran on your videos. So now, this is my point. That's monetization. So they monetizing our form of labor, goods, services, products, content. All of it is what creates the money in the United States. But that can only come from the living, and that is our contribution and investment by things that we take and value and create titles and interests, etc. Right? So now, anytime that we go, they want to use your slave. They're asking you, hey, can we use your surety? Can we use your slave? Can you give it to us so we can raise the capital funding? Right? So they need it to work. So you give it to them to work. But here's the thing. We just usually give it to them without any form of negotiation. And what I mean by negotiation, it has everything to do with the transfer. So anytime you transfer something, you can either, if you transfer it freely without saying anything, then the bearer has the right to do with it whatever they may. But if you transfer it with restrictions saying, hey, I transfer this particular instrument, like a promise to pay or something, right? And when you do this, what happens is, and you put who it needs to be paid to the order of, you reserve all rights and the title and interest in the particular instrument as well. Now what you have did was you restricted it. So now the person that's the bearer now, well, they are restricted to the endorsement, which now means that, well, they don't have rights and interest to the actual note or the bond or whatever the case may be. So they have to come back to you for it. Right? Now, anything that they raise with it, meaning they raise the capital funding, whatever what they sell on the securities market, and all of this comes from using your slave to work off the debt. That's the situation, right? So now when you see this, only thing this becomes now is a trust relationship, and it's a form of medium of investment now, instead of a debtor and borrower relationship. We were never supposed to become the surety for another. Why would I become the surety for another when this is the surety, right? The United States gave you this surety for one reason, but to help set off the debt. It's a taxpayer. So yes, everything should be given to it in its way for it to pay for whatever it is that we're going to do here, right? But if you don't give it to it, then now you just abandon all rights and interests in some form of tangible and intangible property every single freaking time. It's just like when you go get a lease right now. And what you guys will do is this. See, everybody got to perfect the interest according to the UCC. That's another thing. So everyone should be having, you get a lease, you should have a UCC up. With your lease, your rights and interests in the property, etc. But everybody always forget is the address. And, you know, somebody will, well, we didn't create the address. Of course you didn't. You didn't pretty much create anything. Everything you're just in control of. So now that you're in control of it, you have to understand you are in use of it. It's just like the space that you occupy right now. You're in use of that space, and nobody can come and take that space unless they come and do some type of harm and damage to you, or you give it to them. One or the other. But again, that comes from a form of transfer. Now, you could give it by restrictions, saying that, hey, hold my spot till I get back. And I get back, get out my spot. I'm going to get back in my particular space. That's the same thing, guys. It's really fundamental, simple stuff that we really do every day. But you're not looking at it from that perspective, right? So now, once you see this and understand from that perspective, like, you got to realize now, like, you got to make claims to everything. You cannot leave anything open when it comes to commerce, because otherwise, everything in commerce is assumed that whoever bears it owns it until proven otherwise in equity, which means by title, legal title, or equitable title. That's it. That's it. Understand that part. Make sure you understand the claims that we are actually making when it comes to this particular entity, right? And now once you make it, they have to fully come and do everything on your behalf. If they don't, it's now that's where you got them for breach of contract. Absolutely. Breach of contract, right? So I just really wanted to kind of share that with you guys, man, because a lot of people don't fully get how this is actually working and going. So if you make a claim on that actual address, nobody can move you from it. Nobody else has a title or interest. And once it goes into the trust has the right to continue to use it until it's done, because it occupies it at that time, right? See, they might ask for the unit, they might do this, but then I keep saying this, man, all the time because everybody keeps leaving stuff in the public. How do they determine somebody lives somewhere? By the address. And then they will assume since you are an occupant of this particular address, meaning that on paper in the commercial realm, you are in a residence of this, right? Your person is. So since your person is there, then they're able to come. So all you got to do is understand. If that's the case when it works, when it comes to peace officers, as you would say, or whatever the case may be. And when you look at it from that perspective and see like, oh, okay. So in commerce, it has to mean the same thing. Okay? So it just means the same thing. Now you got to make your claim. I got denied after I was approved for a truck for signing with restricted endorsement. So my question is this though. So if you know you did, what do you consider that, Sparrow? Like you gave you, and I'm a solutionist. So you gave me the problem. So now what's the solution? You said I got denied after I was approved for a truck for signing with restricted endorsement. So give me the remedy. We cannot dwell on the problem. So what's the remedy here? Because I know. How did that make you feel when they did that to you? How did that make you feel when they did that to you? Mad. Okay, but what were you mad about? What were you mad about? Come on, what you mad about? Because you got to ask yourself questions. Are they operating outside of their charter? Did you feel like you were discriminated against? Because now, what gives them the right of delegation of authority to limit your power to contract? Think about that. And you say you're right, and you're speaking on your right to unlimited contracting. So what gives them the right to take that away? You got to ask yourself that question. Nah, it's. I mean, yeah, you have the right to put anything on it, but you have to understand they stopped your right of endorsement. So I'm asking you, you got to ask them, show them in their charter, where they were chartered, okay, and that means their articles, etc., where they said that the state chartered them, that gave them the power to take away your power to contract. They have to show that. So you bouncing around everything. They took credits from our trust, all of that other stuff. No, you got to make this simple as possible, and you're gonna make it hard to where you're gonna talk about stuff you can't even prove right now. So you need to understand from the jump, they limited your power to contract. Is that not a form of discrimination to you? Now, let's say the way that you contract has everything to do with your religion, which means your religion say that you should not be a surety for another. I'm just throwing something out there. So if your signature and signing is based upon that, then what do you think that means? Think about that. What does that mean? Because they have to deal with this discrimination now. They have to deal with the discrimination no matter what. Because we can prove, one, you were approved with everything. Okay? You were approved with the contract. You received it all until you exercise a part of your religion, which is based upon how you sign something to ensure that you were operating within honor according to the UCC and your faith. And that's a form of interference with commerce. They are trying to shut us off. It said couldn't connect. Try to reconnect now. Man, I got the best internet around ever. Shoot, my internet is strong enough to hold about 200 people on it. I mean, everybody could attach on it. It still runs smooth. They don't want y'all to hear this. It really just said that. You see that, don't it? I don't know why. But anyway, I hope y'all get the point though, man, of what I'm trying to tell you guys, man. So I really appreciate it, man. I thought it was gonna be a 10,000 likes day, but you guys didn't get us there, man. Dang, I guess the information's not good enough for 10,000, man. Come on. It's all good though, man. But y'all gotta really understand. But just what I'm telling you though, like we gotta stop giving away stuff. We are everything here into this system. Like we created it. The order is God, is God, people, government. The first union has to happen with the people, families. Families turn into to communities, etc., and so on, right? That is the union. That union can never happen. You know, the state of union can never happen without the union of the people, first and foremost. We can't just skip an order and think that everything's going to be fine. That's the reason why, like, even when I said when it comes to court cases, like we were just showing, like now I'm at a point now where I operate and fully in commerce with them, and you know, because of the Clearfield Trust Doctrine as well, to where they are operating in commerce through bonds and things like that in court that holds forms of penal sums, which deals with commercial paper. So automatically they're operating have to operate as a private corporation now. So now they got to prove forms of contracts and stuff like that. Well, I don't want them to prove a contract. I'm going to prove the contract, right? So now the way I'm going to prove the contract is the fact that I'm going to go get the oath and bond. And once I get that oath and bond is going to show that I have a preceding contract with you. And that preceding contract is you took an oath to the U.S. Constitution and the state constitution to fully protect it, which means you're protecting the rights of the people from being infringed on upon this particular municipal or whatever that you're involved in. So now you have to operate on that. Now, if I go there and it's not there in the county or in the form of whatever the city municipal says that they're supposed to record their oaths, etc., and if I go and it's not there, then now you illegally holding the office. We're going to hit you with a court warrant tow. Yeah, and that's also treason. It's treason. I'm going to hit you with that too. Yeah, everything that you're doing is a war against the people. So now we're going to hit you with treason. And treason is not a good thing to be hit with. So that is a fact. But all of this is going to be spoken about at the private administration, at taxation, all of it. We're going to speak about it here at this conference. So you guys got till the 4th. So you got 2 more days to log in with us. Never mind the where it says November 30th. You got longer than that. So screenshot this. Do what it says if you want to be a part of this class. It's going to be dope. A lot of what you heard in here today, and you got to realize that is from season 2. So we're further ahead, way more skilled, way more knowledgeable. Still, that's the base foundation, though. So I'm not going to say dilute that, but it's still, that's where we came from to where we at now. And we still operate within that facility as well still. So none of that really changes anything. But I just want to really lay that out, man. And I just appreciate you guys tonight, man. And it's been beautiful. Hope everyone loved this. Know that you can always follow us. If you ever want to look at this for anything, just make sure that you come to the In God We Trust Academy on YouTube, Twitch, as well as Facebook. And follow me, Eric Ingram Bay, on Facebook and on Twitter, MNRP 619-2020. Again, 619-2020. So make sure that you get there with us, man. And I am ready. All right. I am ready to, continue to spread this information. We got until March for season 5 of work sessions. So we still kicking in on that. So just know every Mondays and Wednesdays, we're going to be here. Mondays, 11 a.m. Central Time. Wednesdays, 6 p.m. Central Time as well. So, man, I appreciate it. I appreciate you guys. Anybody wanted on Call of Duty, come find me. MNRP 2023. PS5. I'm with it. You know what I'm saying? I just had to throw that out there on the slide a little bit. But, yeah, man, it's up there. I hope to see you there, because we got a lot of things to drop. And yes, about the birth certificates, etc. Yes, that will be in the conference as well for those who are new. I know you guys, and yes, you're going to get the advanced version. It's more advanced than the one I filed, which I thought about. But it's still making the same claim. It's just saying a whole little bit more specific things that I found to put in it. So, yeah. So let's jump on it. Let's jump on it. Appreciate y'all, man. It's all love. And yeah, man, if you want to make this conference, then yeah, lock in. Like I say, I really can't wait to do this. I've been working real hard on this. I got a lot of stuff that's going to be said in here. A lot of information that I'm going to be my first time dropping ever, based upon my studies within the past month. So it's going to be interesting. What I love the most is just, I love the testimonies, man. We always got to give back. So, but I'm out of here, man. Y'all have a great one. Y'all have a